Mr. Valderas, let me go to you to go ahead and announce yourself and give me an opening statement on this case.
Yes, Your Honor. Edward Valderas for the Office of Attorney General. The Attorney General's office filed a motion to confirm arrears and modify child support in this case. That was filed back on October 15th, 2024. The parties are present today, and I've conferred with both of them. The child in this case is Jamil Dante Williams, and Jamil, I believe, is 12 and going to be 13 soon. With regard to this case, Your Honor, I have conferred with both parties, and I believe that there is not really a dispute with regard to the amount of child support calculated or the arrears that are outstanding. From what I understand, I think Mr. Williams has concerns with regard to possession and access that were in a prior order. And for the court's information, that prior order was done in March of 2020. At that time, both parties were appointed as joint managing conservators. Miss Denise Chantil Denise Polk was appointed as the primary managing conservator. There were child support calculations. However, the parties had agreed to set child support at $0 per month because Mr. Williams was providing financial support for the child. And there was a government health plan ordered as well with a $57 per month medical support. In addition to that, there was the standard possession and access schedule that was ordered back in 2020. Just for a background terms on that one, Your Honor. And today I have calculated new child support and medical support amounts, as well as a judgment for medical support. And I'd like to call the parties as witnesses to state those terms and see if they are in agreement or not.
Okay.
So the state will first call Mr. James Williams. Mr. Williams, with regard to child support and medical support in this case, I have calculated that child support should be $398 per month for this child, as well as an additional $25 a month for medical support. Do you have any objection to those amounts for child support being ordered?
Yes.
Okay, and what is your objection?
I feel like that's a little bit too much with the standards that I have. Like I said, I'm a father of 5. I have 3 in the household, 3 toddlers that's 2 years old, and like I said, one of my kids have a medical condition. I believe it's like cerebral palsy, and I'm paying out of pocket for those assistance to help him with. So I provide for the home. I provide food. I don't get no government assistance. I don't get food stamps or anything of that nature. And I feel like that's too much for me to be paying for a child that I have no rights to, that I don't get to see. I haven't seen this kid in over. It's been a long time. It's been over. I'm gonna say at least over 6 years.
And back in 2020, were you sending money to Miss Polk for the support?
Yes, that was before she blocked my number and things like of that nature. I have no access to her. I have no access to her family. Only thing I know is addresses and things of that nature. That's why I submitted the exhibits to the court for me doing welfare checks. I just did a welfare check, I'm going to say maybe 2 months ago. The officer that went out to, I believe it's 1703 Weimer, which is her grandmother's house. They didn't get a knock. They didn't get no response at the door. The second address.
Don't give the address. It's fine. You don't have to give the address.
The other address was her mother home, and the officer went out and they said that the kid doesn't stay there. So I have no information of what's going on with my kid. The things that she sent to me to my phone, she told me that his last name was changed to Jamel Dante Sherman. I have football pictures with his name on it saying Jamel Dante Sherman. I have no way to be able to see what's going on with his schooling records. He's basically in school under a whole nother name. So if anything was to happen in life, God forbid anything happen, I have no way to find out anything about this child. The last time I spoke with a family member, they told me that she moved out of state, and in my court order, I was supposed to be able to know where my kid is at any time. I never got him on no weekends, no.
Okay, Mr. Williams, you're saying quite a lot here. Let me just see if I can break it down a little bit here. After you lost contact with Miss Polk, is that when you stopped sending her payments?
I could never send her anything if I had no contact. Yes, sir. Basically, yes, sir.
Okay, and so you think that the child support that I calculated is too high? What do you think it should be if it's not the $398?
I'm looking. Honestly, the money is really not an issue. I really don't. I don't have no problem with providing for my kid. I just want my rights, and I don't know what to do. I don't have money to pay for no lawyer because I'm already providing for so many kids. My rent is over $1,300. I mean, it's going to put a dent in what I'm already doing, and I'm barely making it right now.
Okay. All righty, sir. With regard to the medical support balance, we talked about that briefly, but right now, let's see, at the end of last month, you had a small balance of, let's see, I want to make sure I'm accurate here. At the end of last month, your balance was $108.90. I'm asking for a judgment against you in that amount, $108.90.
That's for medical support, Mr.
Just for medical support only, Your Honor, since no child support was ordered. And Mr. Williams, I'm going to ask that you pay that out back at a rate of $10 per month. Are you in agreement with that amount to pay towards that balance?
Yes, sir.
Okay. And so, if I understand you correctly, your main concern is that you don't have access to your son.
I don't have access to this kid. Like you said, he's 12, finna be 13 years old. The last time I see him, he was maybe 7 years old. So, anytime I ever get him, it's a problem. Like the last time I had him, she basically, the last time I had him, the lady sent the police to my mother's house and said I kidnapped the kid. I had to come outside to show proof of me being his father, and I had to show the court order and stuff like that in that nature. And it seemed like if things are not going her way, I have no rights, basically. When we first went through the court system at the courthouse in Gonzales or whatever that place is out there, like I said, I'm in Houston. She got into it with the judge. She told the judge that she wasn't gonna let me see the kid and stuff like that. So this is just something that's been ongoing. I do not understand how she has him in school under a whole nother name. I just, I don't understand the situation, and I just want, I need more understanding on my rights. So is there any kind of way you can read me my court order and tell me what rights do I have, weekends, or how does that go? Because I know when I read in that paperwork, it said something about she's supposed to I'm supposed to know an address or anything of that nature. But when I was just on this last call, whoever the mediator was at that time, they told me that she don't have to tell me nothing about a residential, where the kids stay or anything. So I'm just trying to understand what are my rights.
Okay, Mr. Williams, I'll go ahead and pass the witness for now, Your Honor.
Okay, well, the first thing, you don't have a copy of that order from 2020?
Yes, ma'am, I have a copy of that order, and when I spoke with the lady and I told her what was in my court order, she was saying that she has no right to tell me anything about the kid as far as the living situation, as far as where he's staying and stuff like that. I have no access to anything.
Was there a non-disclosure finding, Mr. Valderas? I assume not, but
there was not, Your Honor.
Okay, generally speaking, and I haven't looked at your order, so I'm assuming everything's correct. What I've heard here right now is that Yes, parents are supposed to know where the child is residing. And yes, you have the obligation to tell each other if you move and give up your new addresses so you can find each other, one, where to go get the kid, and two, where the kid is when he's on visits. It looks like you had a standard possession order. That's the most that the law gives you if y'all don't agree to something else on your own. And that's every other weekend and alternating holidays and a month in the summer. And if you're over 100 miles apart, 42 days in the summer, which is half 6 weeks, which is half the summer. There's all those rights you have. And Mother's Day, Father's Day, birthdays. There's like 8 pages worth of stuff. If that was attached to it, those are the rights that you have under visitation. However, I don't know what went south with you all and why you stopped visiting, why the visit ended with the last one you just talked about. No idea unless she moved out of state, if that's true. However, today's order, whatever comes out of this court, because there is no non-disclosure finding that was previously ordered, and I don't guess you requested it at this time, Mr. Valdez. There's been no contact between these people, so there should be no, I guess you haven't heard or going to hear that there's any family violence or any charges in the last 2 years or anything like that.
Your Honor, we have requested a determination for non-disclosure of address, but I have not asked Ms. Polk those questions yet as far as why she may want that, if she does or not.
Well, then I'll take that back. If you filed it, I need to hear about it. But technically, if there's been no family violence and no harm or threats or any of that, I don't know what she's going to say. I'll hear it in a minute. Then I have to decide whether she's entitled to it or not. But if she's not entitled to it, today's order will have her address and email address and phone number, whatever the state has. It can be published. Now, for me to actually order it, I have to hear something god awful about what he's done or why you're under some kind of threat of harm, and that it's within the last 2 years. So for that, Ms. Polk, I'll need to hear that. So what can I tell you, Mr. Williams? Why you stopped seeing the child? I don't know. She's probably going to blame you too. I'm going to hear that. I'm going to allow some of that. This is not a visitation case. I get that you, hold on. I get that you're very concerned and you want your rights. The only way you're going to be able to enforce visitation, frankly, is either you figure out how to do it yourself. You're allowed to represent yourself in the state. However, you have to file a motion. You have to ask for contempt of court. You have to put it down specifically what she's done and when she's done it, that she's violated the court order. You have to file it with the district clerk's office. There'll be a filing fee. You have to serve it on Ms. Polk and give a copy to the state. And you also have to get a court date to get in front of a judge to see if the judge will hold her in contempt or try to enforce your visitation rights. Now, if you get a lawyer, it's a lot easier, but it costs money, and I understand you're hard pressed for that. Are you walking? Are you still listening? Is it a problem with your internet? What's going on?
I'm the crew leader. I have my crew, and I was telling one of my coworkers that I'm on this call. I'm just a little frustrated. I hear everything that you're saying, but honestly, after this call, it's still not going to be in no type of way where she doesn't pack fair. You asked me to swear to the courtroom. To tell the truth, the first time I just talked to my kid was 2-3 days ago, and that's because he's residing with her mother right now. The mother let him call me, and my kid basically. He's
So wait, hold on. The child is residing with the maternal grandmother, Ms. Polk's mother. Is that what you just meant, or no?
Yes, he's staying with the grandmother. But
you don't get to talk now, Ms. Polk. You're gonna get your chance in a minute. Let me finish with the story.
When I done the welfare check, the exhibits I sent to the courtroom. I don't know if you could see that or stuff like that. But I done the welfare for Gonzales County, and I also done one for Flatonia. I submitted this to the courtroom just recently, like 2 days ago, and I also submitted it like I'm gonna say 2 months ago when I had the last hearing.
Okay. Well, okay. I'm letting you tell me your story because I think it is important. If I can resolve anything, it's not going to be with a court order because the visitation issue is not in question today, it's just the child support. But if you want to hear your rights, I'll be happy to answer any other questions you may have. But the first thing is you have a copy of your order. And the other thing is we need to find out where the child is and not necessarily publish an address here on live stream. But let one more thing happen in this courtroom before I talk to you again, Mr. Williams. We got to take care of some other business. Ms. Leas, do you want to take care of the Motorola? Somebody? Okay, the person listed as Motorola, if you can unmute and identify yourself, please.
Yes, ma'am. Laura Greathouse.
Okay. Were you already here? You got dropped, or are you coming in? Are you coming in for a 1030 case?
For a 10 o'clock case. I'm not sure if I'm on the right one. It's for a child support.
You're Laura Greathouse, this is a child support court. You're actually talking to the judge, and I'm having a hearing right now. So I wanted to identify who you were so I could put you.
You're an hour early, ma'am, so call back in about 45 minutes.
Yeah, please do that, ma'am. Thank you.
Okay, sorry about that. Thank you.
No problem. Thank you. Okay. Let me get down to business, Mr. Vonda. Let's go ahead and call Ms. Polk and see. Let me hear the other side, see what happens.
Yes, Your Honors. State will call Ms. Chantel Polk. Ms. Polk. Well, first of all, with regard to the child support numbers that I calculated and talked to Mr. Williams about, do you have any objection to those, ma'am?
I don't.
You don't?
No.
Okay. Your voice is very, at least on my end, it's hard to hear. But I think I'm pretty sure you said no. Okay. Then with regard to what Mr. Williams has talked about, not being able to see y'all's son, what is your response to that, ma'am?
Last time he seen him, he refused to bring him back home when he was supposed to. So yes, I did have to call the police because he was supposed to come pick him up and bring him back. He said he wasn't bringing him back. I would have to go find him and all of that. So I called the police, and that's why the police went for my child.
When did that happen?
That happened in 2020. He said he haven't seen him in 7 years. He's seen him in 2020. He's seen him after
right
that.
Off the top of the bat, right after the court order of 2020?
Yep, he's seen him right after that too. He's seen him. This has all happened from 2020 until now. He has seen him within the last couple of years.
And since then, what has been the situation? Has he been asking you?
No, he don't. He said he want nothing to do with my child. Last time my child talked to him was maybe 2 years ago, minus the other day. Last time my child talked to him was 2 years ago. He told my child that he didn't want nothing to do with him because my child wouldn't tell him any information about me.
And do you have him blocked on your phone or on social media?
I do because I have him. He's not blocked on social media if he wants to reach out that way. But as far as him calling me, yes, he can't call me. I don't want him to have my phone number, none of that, because he's real disrespectful. He sends threats. He's just not a person who I want to deal with as far as anything other than I have to.
Does he know where you live right now?
No, I told you not to ask you about your address, darn it.
I'm sorry.
Okay. Ms. Polk, does the child live with his mother? I mean,
Yes.
with your mother?
No, the child lives with me. Do he stay with my mother sometimes? Yes.
Okay. If you were to move, would you want Mr. Williams to know where you live?
No.
Do you want your information with regard to your address, phone number, email address? Do you want that information to be kept out of the court order?
Yes.
Do you believe that if he did have that information, that he would cause you harassment, abuse, or harm?
Yep.
And why do you think that?
Because he has always been an abusive person. Even when me and him was in a relationship, he was an abusive person. He's always an aggressive person. He's not somebody who...
Ma'am, you didn't get a non-disclosure finding in 2020. I need to know what happened in the last 2 years specifically that would allow me to grant you a non-disclosure finding at this late hour.
Because he has sent threats within the last 2 years. In 2023,
that's not good enough. I need to hear specifics.
Okay, that's fine. Well, I mean, I don't have any contact with him, so I'm not allowed. I don't want him to have my number or my address.
It's not a thing of convenience or whether you want it or not. There's a burden that you have to meet in order for me to give that to you.
Okay,
it has to be that bad for me to stop the information. I didn't hear you. You want it?
That's fine. You can put it in there. But I have to get back to work. That's
Look,
fine. It doesn't matter.
if he's not behaving himself, if he's on the phone, you hang up. You just text. If he's not behaving himself, he's calling and harassing you on the phone. There's called telephone harassment. You can call the cops and do something about it. But you have to also prove it. You can't just say it. Okay? And that's what I need for here now. If you really want it, I need to hear something specific. I haven't heard it yet. And I'm telling you that you need to behave too, Mr. Williams. I don't know what's happened in the past. I don't care. In the future, you can't do any of this stuff because it could land you somewhere you don't want to be if you are taking harassing or harming or threatening or those kinds of things. Now, it looks pretty bad between y'all if y'all can't even talk and you haven't seen the child in a long time. I'm going to hear the rest of her story. I'll come back to you, Mr. Williams. But there's things I can do here today to try to fix it. There's an app called App Close where you download the app, you fill in your information. It's free and you can use it. And it's a way to communicate. It's a way to keep things in writing. And so if somebody's misbehaving, you can always get a report from the app to use it in court to show anybody else. You don't have to do screenshots. You don't have to do whatever. So you'd have a way to, and you can't delete things. So you have a way of proving things if necessary and a way of communicating if you want to get to the point where you should be, which is parents of these child that can co-parent, or at least that it not be this hostile that I'm hearing, because this is getting you nowhere. Let me ask you real quick, Ms. Polk, did you change the child's surname?
My son's name's been changed even at court in 2020.
You're saying the court order included it and I signed off on it?
In 2020, his name has been changed. His name has been Jamel Dante Sherman since maybe 2016 or 2015. It's been that long.
So
The birth certificate.
James is not on his birth certificate.
No, that's not what I asked. Is the child's surname Williams or on the birth certificate or something else?
It says Jamel Dante Sherman.
Mr. Balderas, can you address that?
Your Honor, the 2020 order states that the surname of the child is Williams.
And so you never took it to the file statistics and tried to update the birth certificate to put Mr. Williams on there and the child's new surname?
Nope.
And why not?
I don't know.
Well, I don't know if you agreed to it or I ordered it, but it's a court order that says it. So you have an obligation to do that. Now you've just totally messed things up with a kid being known one thing legally and another thing with all the records. I can't believe nobody asked you for his birth certificate. What does his social security number have?
Jamel Dante Sherman. Everything has Jamel Dante Sherman.
So you never had to show a court order to anybody, or they never doubted that you had the right name? Because it's wrong. You have a court order that child's name is Williams.
His name is Jamel Dante Sherman on everything.
No, it's a court order that says it's Williams. You're not hearing me. There's a court order that supersedes everything else. You just didn't follow up with it. You were here. You had to have known. I wouldn't have done it without having a hearing and ordering it, or having an agreement that left it there, or changed it from Sherman to Williams. So that was your duty and your obligation. Mr. Williams, all I can tell you, is he even on the birth certificate at this point?
Nope, he ain't on the birth certificate.
Okay, nobody went to the Bureau of Statistics and updated anything. Mr. Williams, you have the right to do that with a certified copy of your last court order from 2020 that has all that. You can go to the Bureau of Statistics, tell them what the court order says, and have it changed so you're on there and the child's new name is up there too. Now, it's going to create a lot of problems, it's going to be a big mess for the child, but I'm not the one who created that. You all did. So you all want to fix it. You all go forward with it or hire lawyers to get back into court. Yes, Mr. Williams, what?
How am I, why do I have to pay child? I honestly, I didn't believe that she changed his name. I don't even know how she even done it.
It doesn't even matter that the kid has your name or not at this point. If you're the biological father and now you're the legal father, you have an obligation to support the child. I don't care what his name is.
He was born with my last name. So how did she change that if I knew nothing about it?
I'm telling you, she did. If the court order says it, I don't know what the birth certificate has. I don't have it in hand. I never did. But if you think it was always Williams, then then it's there. Go get a copy of it. If you think it was Sherman and the court ordered Williams, then go change it to Williams. You got that right to do that, and maybe that obligation, since she didn't take care of business. It takes two to tango. She didn't want to follow it. She didn't do it. So she didn't go to the Bureau of Statistics. It's as simple as that. I've seen it before. So you can fix it now if you want. And that would be a few bucks, but it wouldn't be hiring lawyers or anything. You already have a court order for that. Now, what happens after that? You want to go to Social Security and change it there? You want to go to all the doctors and the schools and teachers and everything? That's what you have to do.
This is what I'm saying. I work for a government job, and I work for the city of Houston. I have him on my beneficiary and everything. So if I was to die today, he cannot get nothing, right?
If you were to what?
If I was to pass today, in all these years, 12 years, he was born with Jamel Dante Williams. He took my middle and last name. Ma'am, I know this for a fact. When I went to court in 2020, you see in the paperwork, everything saying Jamel Dante Williams. Why does it not say Jamel Dante Sherman?
Because neither you nor she went to the Bureau of Statistics and amended the birth certificate with the court order.
What I'm saying, she's telling you in 2020, I'm supposed to see him. I haven't seen this kid. She's telling you that I'm supposed to be this abusive person. Ma'am, she's dealing with a person that was in the penitentiary. She gave my address to my mother's home. The man been calling my phone, which is her husband right now. She's been calling my phone with threats and all kind of stuff. I have no access to even threaten this lady or anything. So I'm just not understanding how this whole system is working. Why do I have to pay child support for a kid that doesn't have my last name?
It's not about the last name. It's about the court order that says you're the father. You agreed to be the father. Was there DNA done? I don't remember any of that.
DNA was done.
So if you were the father, you're the father. You're the father. You have a duty of support no matter what the kid is called, okay? You can fix the name.
When the DNA was done, his name was Jamel Dante Williams.
I'm not going to fight with you about that. I've heard you say it 10 times. It doesn't matter what you say anymore. This is what the facts are. You have a court order that has your surname for the child. You have a court order you can take to the Bureau of Statistics. You can change it. Okay? Now, the other thing I can tell you is I already told you, you hire a lawyer and drag her to court to get your visitation rights, or then hold her in contempt, or you all figure it out on app close. You start communicating. You start maybe, what about electronic communication? Why don't you start there? Is there any reason you can't agree to an electronic communication order where you can see the child on FaceTime, social media, those kinds of things, Ms. Polk? Is there any reason that couldn't be in today's order?
I mean, we can do FaceTime or social media, but he that's fine.
Ma'am, is there a way I could just sign my rights over? Because I'm not understanding.
No. This is a court that does establishments. We did that. Then we do enforcements or modifications. We do that. We are not a termination court. I don't care what piece of paper you sign. If somebody doesn't file a termination in the right court, this ain't going to happen.
Ain't no way I'm supposed to be paying child support.
There's every way, sir, because you're the biological father and there's a legal order that says you're the father and you've been required, you're going to start paying. Mr. Williams, you're muted because you were talking over me. So now if you want to talk, you can unmute. You're muted. I can't hear you, sir.
Ma'am.
Okay, this is what I want to tell you. There's some groups, there's fathers groups out there.
Listen, can you help me understand? I'm sorry. I apologize. I don't mean to be rude. I'm just frustrated because for the past 12 years, I've been getting used. I've been getting slandered by this lady. She tried to paint this picture to make it seem like I'm a bad person when I'm not. I have no problem with paying for child support, but I have no rights. What just shocking to me, like I said, she texted me before and told me that his name was changed. I never seen no social or anything like that. I'm gonna be honest with you. I thought the lady was just playing with me, but for me to hear this on this call, for her to say that his last name is Sherman, and I've been thinking all this time that his name was Williams. I know for a fact when we went through the courtroom, his last name was Dante Williams. So I'm just trying to see, ain't that illegal? What she done? Like, is that illegal?
Sir, I'm telling you what the legal order says. What she did or didn't do and whether it's a crime, I'm not a criminal court. You need to go figure that out. However, you can still take action. But I agree
to the money. Can we just get off this call? Because I really ain't understand.
But I'm going to tell you one more thing. If you can't hire a lawyer, you can go online. There's some groups that dedicate themselves to helping fathers with their rights. If you want to talk to a father's rights groups and get advice, and or maybe even get a lawyer at a reduced cost, there's some groups out there, Fathers for Equal Rights, something. I don't remember the names of anybody anymore.
fine, ma'am. My mom worked for
I'm
her.
trying to tell you, you're not off the hook. Okay, maybe you're off the hook with no child support all this time. Now,
I'm not worried. The money is not an issue. I have no concern. When I just talked to my kid the other day, and he was telling me how he's not having anything or nothing like that. I buy everything that he ever asked me for. Anytime I ever got to interact with this kid, it's always awkward because it's like she's trying to not she don't want us to bond or anything. When I talked to my kid the other day, he just asked me for money for shoes. I just told him to call me this Friday. I'm pretty sure after we get off this call, she paint these pictures and she's going to go to him and say that he can't talk to me. And I promise you he's not going to call. But I told him to call me this Friday. I would give him the money for the things that he's asking for, like tennis shoes and stuff like that. I have no problem with it. But I know that I'm going to start paying child support. And my main concern is not the money. I just want to have my rights. I don't have rights.
okay, let me ask you, Ms. Polk, without giving an address again, which county do you reside in?
Gonzalez.
Did you actually leave the state at any point in time?
To visit.
Okay. Anything else you want to say, Ms. Polk?
Really, no. I'm just, no.
No, well, you're part of this too. It takes two to tango. If you disobeyed a court order, you did, and you willfully did it, and you don't want him to see. I can see how that happens. I see it all the time. Now is the time. It's never too late to get involved in a child's life. What I'm going to do, Mr. Valdez, do you have anything else to add or subtract to this, or any more testimony to take?
No further testimony, Your Honor.
I do what I do. When I do what I do, I'm sorry to cut you off. When I do what I do, as far as you saying, I need to hire an attorney. My mom worked for a law firm, and I know I can get an attorney. My thing is, I'm finna press the issue on this lady about my kids. So when everything that's going on, from this day forward, do I need to be filing for Jamel Dante Sherman, or am I still doing it for Jamel Dante Williams? Because
the court order is Williams, and you name it. You can say also known as, AKA also known as Sherman, because if you're trying to just identify the child legally, it's Williams, but he's known as Sherman right now, according to Ms. Polk. So you can use either name or both, and it doesn't matter. What really matters if you're filing a lawsuit is that you get the right information from Ms. Polk. What else?
I have no contact, so how can I get the right information if I have no contact? So.
Guess what? I'm not ordering a non-disclosure. She relented. She said it's okay now. I didn't hear enough evidence to even support it. So I'm going to order that there's no non-disclosure. It's going to be in the court order, the information you need.
Is there any kind of way you can see the emails from the exhibits that I sent from the welfare checks that this comes from the police? The same address I'm not going to say the address, but the same address, I've been doing welfare checks there. They said that the child.
Okay. I'm here for your child support case. That's the only thing I can rule on. I've given you plenty of time to tell me what really is going on, so see if I can provide any kind of assistance or any kind of information. But what's the point of me looking at well checks right now that will help you in your child support case? Because that's what I'm doing right now.
Telling me to go to an address. She's telling you an address that she doesn't not even stay at, man. But it's fine. Don't worry about it.
Well, it's the address the state has listed for her, and it's the address that we put in the order, including email, including phone, and I'm going to order the app closed communication as well. There's a couple of things I'm going to do separate apart from what you're requesting, but we'll do the child support in just a minute. Before I forget, electronic communication with the child. Y'all can't agree to anything. I need to figure what days and times and hours or whatever that he can call the child either by FaceTime or some other social media, Ms. Polk. So when can the child be available so I can put it by court order that he's entitled to at least electronic communication that way?
That's all I'm for me to be paying money. That's all I get is electronic.
No,
access.
You already have a court order with standard visitation. This is extra. I'm giving you a way to get there and get to know the child before you get possession of the child, because you are entitled to visitation rights under that order, unless she gets a lawyer and modifies it to prevent it, which I can't guarantee anything here. I don't know what y'all are going to do, but I'm going to give you one more way to communicate with the child. It's in your benefit. Okay, so Ms. Polk, what day and time would the child be available that some kind of communication could happen with dad? Once a week? What time?
Once a week.
Yeah, because he's not getting anything else, ma'am. You're under a court order like he is. You want his child support, you need to provide visitation.
I'm giving you a date. It wasn't a problem. I'm trying to figure out the day. It can be Friday after 6 o'clock.
So there's no football games, there's no basketball games, there's no nothing he's going to be doing.
Right now, it's not, but it will be.
Well, it will be. Yes. Don't give me something that's not going to work. So give me something that
You
might
know
work.
what day it be because he's barely finna be in middle school. He's 11, finna be 12. He's not 12 going on 13. So
Well,
I
there's
don't know.
Saturday or Sunday when you have some downtime that he's
We
home.
can do it Saturday. That's fine.
What time?
We can do after 4 o'clock.
Between 4 o'clock and what?
4 and 6 or 7.
Let's just say every Saturday between the hours of 4 to 6 p.m. for no more than what? Can you handle 30 minutes, Mr. Williams? Is that enough time on social media?
I just want to end the call. I'm gonna get an attorney. I'm gonna do what I need to do.
No, you need to do whatever you need to do, but I still need you to be a part of this for the end of it. So what would work for you on Saturday between 4 and 6 for 30 minutes?
Whatever the custodial parent allow.
I'm ordering it. I'm giving you a chance to tell me how much time is enough time.
10, 5, whatever is available. I don't care. Whatever is
I'll
available.
do 30 minutes would probably be standard for any kid on a phone or actually on the social media. Okay. Electronic communication every Saturday from 4 to 6 for 30 minutes. Then I'm going to order the app close communication. So you're both ordered to download it. It's going to have the email, the website in which to download and set up the account. It's for free. That's a way for y'all to communicate with each other and share information or documents or whatever else. I'm going to ask that the state put the, which would be best? Which do you have? The Children's Bill of Rights or the Loving and Caring Order or even both, Mr. Valderas, one or the other?
I do have the Children's Bill of Rights, Your Honor. I don't think I have the Loving and Caring Order.
Okay, the Children's Bill of Rights, it tells parents how to act, what to talk to the child about, what not to talk to the child about, how to treat each other. Children's Bill of Rights will be attached to the order.
Yes, Your Honor.
Okay, and on the issues that are actually before the court, let me find it. You said the medical support judgment was not an issue. I'll grant it $108.90.
Yes, Your Honor. As of March 31st.
$10 a month starting what date, Mr. Valderas?
May 1, 2025, Your Honor.
That would be fine. On the issue of child support, you said the guideline was where did
$398, Your Honor. And that's giving him credit for 4 other children.
I'm going to, I think it's important that dads have their rights or the non-custodial parent has rights, whether dad or mom. And he has a standard possession order he hasn't been able to exercise. You also now live some miles apart. So I'm going to grant a variance, a small variance to $350 a month to give him ability to have some gas money to come visit the child. So $350 a month starting May 1st for child support, medical support of $25 a month starting May 1st. And what do we do that the insurance mom has it private?
Government health
Government med
plan, Your Honor.
The government med program mother is required to maintain. And then if anything's not covered by insurance, y'all have a 50-50 obligation for co-pays or deductibles. However, Medicaid usually covers 100%. But I will tell you, if you let it lapse and you're ordered to provide the insurance, you're required, Ms. Polk, to pay for all of it if you don't have insurance in effect, as this order is ordering you to do. So you would have 100% liability if you let the insurance lapse. Okay, I'm going to waive court costs on this one. And no, I will need you to put in the order. The request for non-disclosure is denied.
Yes, Your Honor.
Your Honor.
Yes, sir.
As far as my visitation, I understand the electronic stuff. I'm gonna try to do everything that you're saying do. Like you say, I do have rights. So when I drive out there, I've done this several times and I've wasted my time, my gas and stuff like that. It's like a 2-hour drive coming from Houston to Gonzales. So when I come out there and say, for instance, if my kid is not there, once I call the police, do I get a report? And does that is that like my evidence for once I do?
This is what I would tell you. First of all, since you haven't had visits for whatever reason, you're trying to start it to put her on notice. I would tell her by app close or by text, I'm exercising whatever weekend, the one that's coming up, whatever. And you tell her the day and time you're going to be there. That's under the court order, so that you're only getting your rights under the court order. Don't say a different day, a different time, whatever. Don't change it. Tell her you're going to do it. Get a witness or take a witness with you that you show up for that. And hopefully she replies. And then see what happens. And you take photos, you take video, if she responds to you and says no, if she sends a child to the door and the child says no, I mean, any number of things can happen. You try to document it, sir, because it's not until you start documenting that you have the proof, and then you can have a lawyer file a contempt on her. But again, because you haven't seen the child for a long time and there might be a dispute about why, you have to kind of start with baby steps. So I'm telling you, start with the electronic communication, maybe get the child on board with that. He starts seeing you, bonding with you, wanting, excited to go with you or whatever. And then you go, and then you tell her, put on notice, and then you go.
Already kind of been doing the electronic communication. The child stays in Flatonia with the grandmother, and she let him call me every other day. When I spoke with the grandmother, she thought I was mad or things of that nature. She never knew that Chantel had blocked my number on her phone. So I had been reaching out. That was the only person that deals with me, that steals, make sure that me and the kid is able to talk. Like I said, I'm supposed to be sending my son some money Friday, but what I'm saying, I understand you saying take those baby steps and stuff like that, but can I still follow my court order and just exercise my right to use my weekend? Like if I drive out there this weekend?
I would tell you see what weekend, and follow the court order and put her on notice that you're going to go. So she's not going to say, oh, I had other plans. Oh, I couldn't be home. Oh, you didn't let me know you were coming. I had no idea because you haven't come for 7 years. You put her on notice. That's what my general information is to you. Now go talk to your whatever way you want to and get specific advice for your case. I don't know all the facts of your cases. I'm not going to be a judge that hears this mess. So you figure it out.
The apps that you saying download, do she have to download that or what?
Well, that's the only way it would work for communication, that you each download it and communicate that way. You can do that. However, if she doesn't download it and you do, and you can't get through, you still have her phone number, you're still going to have her address. You can email her, you can do whatever to communicate with her if she's not using the app. The app is a good tool, but it takes two to tango. If you can't get her to use it, well, all I can tell you is you have other ways to communicate. And if you have information or you get information, you keep a folder and go to a lawyer and talk to a lawyer. And all this is coming, Ms. Polk, so be prepared for it, because you're under the court order too. It's not just about child support, it's about visitation too. So you do what you can on your own, Mr. Williams, and but you have electronic communication on the days and times I've given you through mom. If you get more through grandmom, well, great. That's not for me to worry about. Okay, was there anything else I need to address, Mr. Valderas?
No, Your Honor.
I'm going to figure that this is a contested hearing and not everybody's agreeing to everything except the numbers. And so I'm going to ask you to put on the signature lines for the parties. The state's going to draft the order, send it to you by email individually. It's going to be coming from the Texas Office of the Attorney General. That would be a priority homework. Open it up, review it, sign the order. It's going to be, and I'll tell you, Mr. Valderas, put as to form only. It's not that you agreed to all this. It's that you acknowledge that this is a court order, because I'm doing some things that are not the child support, but I think they're in the best interest of the child, to get you all to start communicating and allowing some visits. So as to form only, and then I guess I'm going to ask you for one more attachment, the de novo appeal rights, Mr. Valderas.
Yes, Your Honor.
Besides the Children's Bill of Rights. If either of you don't agree with what I did today, go tell it to another court by filing a notice of appeal within 3 business days from when you received the signed copy of the order signed by me. You have 3 days to file an appeal. You got to file it in writing with the district clerk's office. You got to send it to every other party, the other parent plus the AG, and you got to call the coordinator's office to get a court date within 30 days. If you do all that, you have a shot with another judge. If you don't do that, this order stands. It is a final order. It stands now. But if you appeal and another judge does something different, well, that's on them and on you. So you have any questions, Mr. Williams?
Can you repeat that? As far as the appeal, can you repeat that as far as the order and stuff like that?
No, I'm not going to repeat it. I've already said it at the beginning. I said it at the end. What you can do is there's going to be a letter, an attachment at the end of the order is going to have your rights. It's really generic.
It seems like you're not really being fair. If I was telling you I didn't understand it, you saying you can't repeat it, but that's
well,
fine.
If you were listening, you could have understood it. Okay, I won't argue with you. I'll tell you again, but listen. You have to wait to go. The court order is proposed. The proposed order is sent to you. You sign it. Then you wait until you get the copy that has my signature on it. From the day you get my signature on that order through the email system, so you have to be checking, you have 3 days, 3 short days, 3 business days in which to file the notice of appeal. And that it has to be in writing. It has to say what you're objecting to, that I did wrong, if there is some error, or if you have new evidence or whatever, you get to start over in a higher court. You file the notice of appeal within 3 business days from the time you get the signed copy with my signature on it. You send copies to the other party, to Ms. Polk and to the AG's office at their email addresses. You call the district clerk's office to get a court date within 30 days so that you can be heard in the higher court. And that would be in front of the elected district judge. That's the right of appeal from the associate court to the district judges. So that's the generic thing I can tell you about it. There's going to be an attachment that reminds you about some of it or tells you what section of the family code to go look at. But don't wait for somebody to call you to give you a court date. It doesn't work that way. You lose your right. You need to call and get a date within 30 days from when you file. That's part of it. Got it?
Ma'am.
Okay, or talk to your lawyer at your mother's office, because they might give you better advice knowing more about the facts of your case. Ms. Polk, do you have any questions?
No, I don't.
Okay, then you have your court order. The only thing I would suggest, Mr. James, is you get a certified copy out of the Gonzales County District Clerk's Office. They certify that the copy is a true and correct copy of the original in the court file. Might be a few bucks for that, but it might be worth it to you because you'll need it for the Social Security Office. You'll need it for the Bureau of Statistics, where they see where the child's name legally is if you want to get on the birth certificate and put the child's name back to Williams. Okay, and Mr. Valderas, any other admonitions for either of these?
No, Your Honor.
You don't-
We'll have that order drafted and sent out to the parties later on today.
I assume you have their current email address or current residence address or current phone numbers. None. You don't need to update that off record before I let them go.
I believe I do, Your Honor. I have no indication that it's different.
Okay. Then that'll conclude this hearing. All I need you to do, Mr. Polk, Ms. Polk, Mr. Williams, is click the end meeting buttons. You're done with court today, and look for the order this afternoon, or hopefully no later than 5 in your emails. Thank you. Good luck to both of you and your child.